May it please the court, my name is Charles Lincoln, and I represent the defendant in this case, Vista View Apartments. Vista View Apartments is being sued because of an injury that occurred on its property on January 21st, 2015. The plaintiff in this case argues that the injury should not have occurred because the defendant, Vista View Apartments, owed a duty based on foreseeability to protect people living in the apartment complex. The duty of foreseeability is based on five factors from the timber law case that we here in Texas have decided is law. So liability is based off a breach of duty, and that duty is based off foreseeability. The five factors from the timber law case are that evidence of similar crimes in the vicinity had occurred, Opposing counsel will try to show that an adjacent lot with a police beat next to the lot had 6 crimes that occurred. The adjacent lot, what does that mean? It could mean a block next to a block, or it could mean the entire area as big as North Texas. It sets up a bad ruling and a bad policy for courts and juries alike to follow. The recency. Opposing counsel will show that in the past year, crimes have occurred in the adjacent lot. Past year, other courts have seen past week, past days. Past year seems like a long time to base an argument. A lot can change in a year. Frequency. Opposing counsel will show that frequency of the crimes occurred quite frequently, but there's only 6 times. 6 compared to hundreds, and sometimes thousands witnessed in other cases. 6 times seems like a really small amount. And sufficiency of a similar crime. Members of the jury, this was a crime that occurred. That was a property crime. A property crime. Property crimes aren't similar to violent crimes. And finally, the opposing counsel tried to distinguish that point by bringing up a case from San Antonio that discusses a person of reasonable intelligence could deduce that such property crimes could lead to violent crimes, but here we're talking about vandalism, so that case is clearly distinguishable. We're not talking about huge guns blazing out. We're talking about mere vandalism. Finally, publicity. Publicity of the record. Opposing counsel will show that there was a police record and it was available to the public. True, but how can we reasonably expect property managers who are day in, day out working for their tenants to make sure everything is all right on the property be well? We can't. And therefore, the evidence shows that the defendant is not liable in this case.